when I first looked at this, which was 1971, 72, when I was in law school, and wrote my first law review article, I wrote one article about 7 or 8 topics that had hardly been looked at before at all, some of them not at all. And that one article, it was 10 or 20 pages. Now there are books about individual topics, like restraints, like the right to refuse treatment, like the right to treatment. So there were many people who began in that period around the 1970s to say, when people are in the institution, do they have a right to say no to drugs? Do they have a right not to be put in seclusion or restraints? With what kind of procedures? Do people have a right to visitors, to access for advocates? And then as folks began to think about those questions, the question arose, what happens when people don't need to be in an institution? People like me and other advocates, including Bill Johnson here in Minnesota, people began to say, maybe we don't need either as many institutions or any at all for some folks. So there began to develop, out of the litigation around conditions in institutions, litigation like the Halderman versus Pennhurst State School and Hospital case in Pennsylvania, Wyatt versus Stickney in Alabama, the Willowbrook case, New York Association for Retarded Citizens versus various state officials. There began to develop litigation that said, number one, we don't need bad institutions, and number two, for some people, there's no need to be institutionalized at all. So that kind of litigation began to move through the courts, and eventually, in 1990, the Americans with Disabilities Act was passed, which referred in its preamble, I'll call it, to needless segregation of people with disabilities, but didn't directly address what the rights are of people in institutions. The U.S. Supreme Court in 1999 decided the landmark case of Olmstead versus J.C., and in that case, for the first time, the Supreme Court declared that needless institutionalization itself is discrimination because institutions segregate people with disabilities from people without disabilities and therefore is illegal. So we have, without right now going into all the history, we have really a shape, I think, to the social and legal developments around people with handicaps and disabilities, where we begin with social moral considerations, move into a rights orientation, rather than it being a good thing to do. It's the right thing to do. It's a legal right. And then where the focus begins to develop and shift from how we get into institutions, what happens when we're there, and then whether or not we need to be there at all. Some reflections on some of the work I've done and some of the cases that I've done, because it's been an interesting journey for me. In 1971, 72, I was finishing law school and created the first mental health advocacy project in an institution in the United States. 2 foundation grants, an office with a desk made out of a table propped up on 2 sawhorses, a typewriter borrowed from a former mental patient, and I began doing this work at an institution called Haverford State Hospital in Pennsylvania, and brought some of the early lawsuits that nobody had ever done before. Brought one case involving the right not to be forced to do labor, Downs versus Department of Public Welfare, the first case that ever declared that forced institutional work, which used to be the norm, violates the 11th Amendment ban on slavery, on involuntary servitude. I also brought there a case that I never thought would take as long as it did, and that was the case involving the rights of children not to be committed to institutions simply on the say-so of their parents. I represented a few individual children in a class action, and in one of the hearings in front of a 3-judge court, the court said, well, these are kids, don't they need a guardian ad litem for the lawsuit to represent them? And I deferred to the judge. I said, maybe they do. And the judge right there and then appointed me the guardian ad litem of all 6,000 children in all Pennsylvania mental institutions. And I had that responsibility through a couple arguments in the Supreme Court. When I began the Halderman versus Penhurst State School and Hospital case, it was one of the first suits I filed. I'd been a lawyer just a couple of years. Never thought it would have such an impact as it did. And the way that case began is worth recording because it really exemplifies how many other cases have proceeded. Terry Lee Halderman, who'd been injured at the institution 30-some times, I think, her mom was upset, and her mom asked the assistant superintendent, what should she do? The assistant superintendent told her, call David Ferleger and sue me. So that case began not because I was there for some other reason. I'd done mostly mental health, not intellectual disability type cases, but because the institution itself, an official, said, we need to be sued about what we're doing. The case was in front of Judge Raymond J. Broderick, an incredible federal judge, a Republican, conservative, who through the course of a 32-day trial eventually ruled that no one with retardation, now called intellectual disabilities, needs to be in any institution at all, and that people have a right to live in the community. So I've counted it up once. I think I've been in 30 or more states looking at institutions or litigating in institutions. And the images, unfortunately, stay with you for a while. In a Wyoming institution, I remember a very dark room with volunteer sort of grandparent types holding very little children, trying to rock them to sleep or comfort them. Children who need never have been in an institution at all. In Florida, as a court-appointed monitor, I'd heard that they were using a new kind of restraint and went down on behalf of the court to see what it was. It was called a mat wrap, in which the client with the behavioral outburst, let's say, was rolled up in a mat. And I, thinking that I was protected by the court order, protected by the other 2 court monitors there, the head of the institution, I ingenuously, I guess you could say, volunteered and said, well, let me try it. Let me have myself wrapped up in the mat. They hesitated. I lay down, stuck my head out, tried to use my elbows to give myself some room, and they rolled me up in this mat. And it was the most terrifying experience I've had in my life. I felt that I would never get out, even though I knew intellectually that they wouldn't wrap up a court monitor for hours, but it was so terrifying for me, who could intellectually understand what was happening, and it made me really think about what the experience is like for someone without that much intellectual capacity, who doesn't know why, doesn't know what's happening, doesn't know how it will end, what to do to make it end, and how incredibly traumatizing that would be to someone without the kind of capacity, I thank God, that I have. So among the things that have happened that people in my generation of advocacy have seen is the closing of institutions. In the last 10, 20 years, dozens of state institutions for people with intellectual disabilities have closed. People have moved to the community. Governments have seen, the community has seen, that people don't need an institution to have a quality life. The right to education laws have helped. Children are no longer being admitted to institutions. And so we've seen some really wonderful changes. It's been quite an experience for me, an amazing experience to be able to argue some of these cases in the U.S. Supreme Court. The court gives, everyone who argues finds on their table a little quill pen that's hand-carved from some goose's feather, whoever it is that contributed the feather, and that's one of the things that's left. Another thing that's left is sort of one of the stories that I like to remember, and that was in the case involving children and children's rights to a hearing or some process before commitment. The state's lawyer argued that children could file a petition for habeas corpus. A child unnecessarily locked up could go to court and say, I shouldn't be here. And that was an alternative to my proposal for some kind of hearing. And Justice Thurgood Marshall said, what are you saying? How can a child file a petition of habeas corpus? And the state's lawyer said, well, if the child couldn't do it, then a friend could do it. And Thurgood Marshall, famous for his humor, he said, well, aren't most friends of 12-year-olds also 12 years old? Everybody laughed, and we went on. So what will the future hold? The future will hold fewer and fewer institutions, more scrutiny of quality community care, and some developments that I think will occur in the law regarding community life that deserves some attention elsewhere.